At the jail, please state your name for the record.
John William Huntley.
This is case number 25-4334 SM, the people of the state of Michigan versus John William Huntley. Sir, you met with somebody from Community Corrections today and gave them some contact information. Is that information accurate?
Yes, it is, sir.
Did you have the opportunity to meet with somebody from the defender's office today?
I did.
I have a complaint that alleges that on or about August 10th, 2025, in the village of Niesick of Wexford County, it is alleged in count number 1 that you committed the offense of aggravated assault. That is a misdemeanor punishable by up to 1 year in jail and or a fine of $1,000, and consecutive sentencing may be imposed if it happened in a place of confinement. Do you understand those charges and the potential penalties?
I do. I don't know the person in general that I apparently committed them on, but that's a later date. But yeah, I know.
Do you know who the charge alleges that you were allegedly assaulted?
I've heard the person's name. I don't know the person, so okay. I think you got me.
All right.
So.
Okay. Did you read and sign an advice of rights form there at the jail? Talked about your rights to an attorney and your rights to a trial?
I did, sir.
You do have the right to be represented by an attorney at all phases throughout this process, and if you could not afford one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
Request an appointment of an attorney.
All right, court will make a referral to the public defender's office for the appointment of an attorney. We'll enter a not guilty plea on your behalf, and we'll set the matter for a pretrial. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Counsel, historically, I show in 06, driving the license suspended, in 10, a driving the license suspended, another one in 10. In 19, there was a use of methamphetamine. In 20, an attempt to resist and obstruct. In 23, a driving a license suspended. In 11, there was a 4A case. In 09, there is an operating without a license or failed to display a license. The defendant currently has a warrant for probation violations for a controlled substance case and has, by my count, 4 failed to appears in his past. The praxis scores him at a risk level 5. Comment regarding bond, Mr. Harris.
Indeed, it's our understanding that Grand Traverse County has a hold on him, so due to this warrant that they have for a probation violation, so it's somewhat academic. I would have you set a bond, a nominal cash bond, so once that matter is resolved and the hold is lifted, he could apply it and be released pre-trial in this case.
Thank you, Ms. Lawrence.
Thank you, Your Honor. And it's my understanding the defendant does in fact know the victim, at least based off the report. The victim was the defendant's girlfriend's ex-boyfriend. And he essentially attacked him completely unprovoked. The victim did have pretty serious injuries, bruising to his face, a nosebleed, possible broken jaw. He was at a later point evaluated by EMS. I would ask for no contact with the victim. While I understand this case is a little bit older, our office has not had contact with the victim at this point in time, so I would still ask for that. I would ask for a higher monetary bond. I think his outstanding warrant, as well as his several failure to appears, clearly show that he is a flight risk. And I have serious concerns that if given the PR bond, despite the hold he currently has, we likely would not see him back here. So I would ask for a higher monetary bond in this case. Thank you.
All right, thank you. According to Lean, it looks as if he has been missing from Grand Traverse probation since July 8th. That looks like that was the first fail to appear. Defendant was also on bond at the time that this event happened, and as I said, it looks like he's got 4 prior fail to appear, so I do find him as a flight risk. Accordingly, I believe a monetary bond is appropriate. Court will set the bond at $10,000 cash surety. Defendant is to appear as ordered, keep your contact information current, not leave the state without permission, and commit no new crimes. I'm also going to order that you not have any contact with Justin Greenwood. No contact means no contact of any kind, phone, text, email, social media, or anybody acting on your behalf. If you are found to be in violation of your bond, you could be arrested without a warrant, brought back to jail, and have your bond revoked. I'm also going to order that you not purchase or possess any firearms or weapons. You not act in any threatening, intimidating, or harassing behavior. Sir, could you please state your name for the record?
Blaine Merritt.
All right, this is case number 19-3548FY. The people of the state of Michigan versus Blaine Merritt. Mr. Merritt, you met with somebody from Community Corrections today and didn't give them any contact information. Do you not have a phone number or mailing address?
Nope.
Did you have the opportunity to meet with somebody from the defender's office today?
Yep.
Is that a yes?
Yeah.
Sir, I need either a yes or a no, please.
Yes.
I have a complaint that alleges that between the dates of August 1st, 2015 and December 31st of 2016, it's alleged that you failed to pay child support based on a order from the Wexford County Circuit Court. As of the filing of the warrant, which was back, or the filing of the complaint, which was back on July 15th of 19, the amount outstanding was $20,032.13. Do you understand those charges and the potential penalties? I'm sorry, that's a 4-year
Yes.
felony. That means you could be sentenced to up to 4 years in prison and or a fine of $20,000. Do you understand that? 2,000, I'm sorry. Do you understand that?
Yes.
On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning you consent to, and the right to stop answering questions at any time. You also have the right to be represented by an attorney at all phases throughout this process. If you could not afford one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
He's attorney sitting right there. I already talked to him.
Well, he hasn't been appointed yet. So, and even if we do make a referral for an appointment, there's no guarantee it would be Mr. Harrison. But are you asking for the appointment of an attorney?
Yeah.
All right, the court will make a referral to the public defender's office for the appointment of an attorney, enter a not guilty plea on your behalf, and will set the matter for a preliminary examination. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecutor will be required to prove two things. One, probable cause that the crime had occurred, and two, probable cause that you were the person who had committed the offense. If the prosecutor is not able to do that, the case would be dismissed. But if they are able to do that, you'd be bound over to stand trial in circuit court. Prior to the preliminary examination, there'll be a probable cause conference. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Historically, counsel, I show in 12 and operating without security, in 15 have failed to pay child support, in 12 operate without an endorsement, and in 95 there was a trespass charge from out of state. The praxis scores at level 6. Any comment regarding bond, Mr. Harrison?
Well, I remain a bit confused with regard to the status with the court. I realize you present something of the memo presenting no fixed abode and or contact information. That point seems obvious to me that this is an extremely old case. The warrant that I was provided was signed by Judge Bill Fagerman in 2016.
Yeah.
So obviously he hasn't had substantial contact with police or courts or anything in the interim. And I don't see any reason, other than the obvious ones, why retaining him now makes any sense. If we could find him a place to go and a contact to have, we might be able to obtain his pretrial release in terms that would be acceptable to the court. At this juncture, given the situation with the case upstairs, which we'll be addressing at 3:30, I would have the court set a bond so credit is properly allotted.
Thank you. And we'd heard from the Attorney General's office that they did not plan to appear today for this arraignment. Given that the defendant, so it appears, based on lien, that he was put in absconder status from probation back on November 21st of 2016. So he has been an absconder from court supervision for some 9 years. He does not have a mailing address, contact information, so I do find him a flight risk. The statute does require that bond be set at least 25% of the amount owing, which at least back in 19 comes to $5,008 and some change. However, given that he has been absconding in another case, a bond will be set at $10,000 cash. If he is able to post bond, he is to appear as ordered, keep contact information current, not leave the state without permission, and to commit no new crimes, and must enroll in community corrections services. Corrections, can we have Mr. Bowler, please?
Yes, sir.
Sir, can you please state your name for the record?
Christopher Lee Bowler.
All right, this is case number 25-5160 FY, People of the State of Michigan versus Christopher Lee Bowler. Appearances, counsel?
And Carnes on behalf of the people.
Heard self, Mr. Bowler, joint specimen from the Wexford County Jail.
All right. And we were originally scheduled for a preliminary examination. However, I see that there's a waiver attached to the file for me to sign. But there's also been a third amended complaint filed in this case. And so before I sign the bind over, we need to arraign Mr. Bowler on the amended complaint. Mr. Hartel, were you aware of that?
Yes, Your Honor, and I have discussed those changes and why they're being changed with my client.
All right. So, Mr. Bowler, the new complaint alleges that on or about December 23rd, 2025, in the city of Cadillac of Wexford County, it is alleged in count number 1 that you committed the offense of police officer assault, resist, or obstruct. That is a 2-year felony and or a fine of $2,000. And consecutive sentencing may be imposed if it happened in a place of confinement or for another violation arising out of the same occurrence. In count number 2, it's alleged you committed the offense of malicious destruction of a building, $200 or more, but less than $1,000. Is there PC on that?
Which one?
Count 2?
Yes, yep, there is a new PC that came through.
That is a misdemeanor punishable by up to 1 year in jail and or a fine of $2,000 or 3 times the amount of the destruction, whichever is greater. In count number 3, it's alleged that you committed the offense of public officer assaulting or obstructing. That is a felony punishable by up to 2 years in prison and or a fine of $2,000. And again, consecutive sentencing may be imposed. In count number 4, it's alleged you committed the offense of public officer assaulting or obstructing. That again is a 2-year felony and or a fine of $2,000 with potential for consecutive sentencing. In count number 5, which is the new count, it's alleged you committed the offense of malicious destruction of personal property, $200 or more, but less than $1,000. That in of itself is a 1-year misdemeanor and or a fine of $2,000 or 3 times the value of the property destroyed or injured. However, they are charging you as a second or subsequent offender because you had a prior either completed, well, it looks like it was an attempted malicious destruction of property, $200 or more, but less than 1,000 from back in 2020. That makes that 1-year misdemeanor a 5-year felony and or a fine of $10,000 or 3 times the value of the property taken. I'm sorry, destroyed. They've also elected to charge you as a habitual offender 4th offense, meaning you have at least 3 prior either attempted or completed felonies in your past. That makes each of those 2-year felonies a 15-year felony, and the 5-year felony up to a life offense. Do you understand those charges and the potential penalties?
Yes.
All right, you do have the same rights that you had during your other arraignment, so we will go ahead and continue the appointment of an attorney and enter a not guilty plea in this case, and continue the bond as previously set. Counsel, before I sign the bind over, is there anything else we need to address for the record?
There. No, thank you.
All right, then I will go ahead and sign that, which I have done. So thank you, Mr. Bowler. Thank you, Jail.
Thank you, Your Honor.